Hello and welcome to Business Immigration Online. This presentation is about employment eligibility in the United States. What are the controlling principles of the verification system? The first principle is that unrestricted employment in the U.S. is a right reserved solely for United States citizen and lawful permanent resident. There are some smaller groups, but these are exceptions that are very small and limited. Other foreign national must have specific authorization to accept employment in form of a visa or other employment document. EAD stands for Employment Authorization Document. Um, Employers are those responsible to enforce the rules about hiring only authorized people, and employers may not conduct a verification or act or have employment practices that are discriminatory. The employer, as you see in this process, get quite a bit of information about the employees, and they want to safeguard the information so that the employer does not unduly use their force or otherwise engage in practices that are um, inconsistent with the rules of our legal system. What are the procedures? The procedure, as we saw, are based on the I-9. This is the main instrument that through which this program is administered, and it has to be filled for every employee. It has to be started on the first day of employment and has to be completed by the third day of employment. After that, it's a violation if the employee is working but the form was not completed. There are three main parts for the form: one for the employer, one for the employee, and another one that is for re-verification. The list that we refer to in terms of the document that can be presented are in the instructions, or are actually a part of the I-9 at the end, and those list the documents. List A are documents that establish both eligibility to work and identity. List B and C, one just show identity and the other one just show eligibility to work. This is why you need one from each. So it's either a document from list A or one from list B and one from list C. And as we will see later, and we mentioned before, no one is eligible to dictate to the employee which documents to bring from those on the lists. Um, the employer fill one part, the employee fills up the other part, and bring the documents for inspection by the employer. The employer would usually keep a copy of these documents as evidence that they were actually presented. Again, the employer is obliged to administer the process and make sure everything was done correctly. Re-verification is something that the form enables in case of when someone is rehired after absence or something of that sort. Many employers don't bother with this and just go and do a new I-9 altogether. It's perfectly okay. Um, the re-verification is something that really is of limited benefit, but it can be used so people don't need to fill everything again if this is a very big concern to them. The compliance. The compliance, again, is the responsibility of the employer. If the employer detects deficiencies in the I-9, they should be fixed, and the record should be kept correct to indicate what was missing and what was happened, and things need to be signed properly and documented. If I-9 is lost or destroyed, a new one should be completed. If the person, if there was a water main break in the building and all the files were destroyed of the I-9s, new I-9s should be completed. The retention of the I-9s can be either in hard copies, which is okay if you have just a few employees in one location, but can be also electronically or in other methods that is easily or that is retrievable upon request. So it cannot be encrypted in a way that there is no way to open it because DHS or ICE will come and will want to look at it. You have to be able to reproduce it. So for very large companies with hundreds of thousands of employees and thousands of locations, this system might be a better way to retain the Forms I-9. Now, the entire mechanism of this program is based on good faith. The employer must act in good faith, cannot keep their eyes shut to things that are like egregious, and must not like turn their head when there is something that might be illegitimate. This is a general principle. If someone acts without good faith, that should be, in certain situations, something that is punishable. Safe harbor, that's the other side of the good faith. If the employer is acting diligently and in compliance with the guidance to the best of their abilities and do what they need to do, they get a sort of safe harbor, meaning um, that they cannot be charged by DHS in technical violation. Their safe harbor again require good faith and require action be taken at a certain standard, and the standard is the reasonable employer. So um, if someone brings a document and it's clearly on its face um, forged, because, for example, the person bring a social security number that coincidentally has the same number as the person who's checking, there is a good reason to assume that there is a fraud there. Or if it's just a photocopy of a card instead of a card, and they say this is what I got from USCIS, all that stuff um, raise sufficient concern that the employer must, take action to verify that this is really kosher and not something that is obviously an attempt to use or to abuse the system. Penalties also follow the same trend, meaning there can be civil or criminal. Civil are the most widely used for violation, either technical or violation that are not egregious and do not come as a knowing pattern. There can be very lax practices that definitely don't meet the requirements, but are not, there's no criminal intent then there to deliberately hire foreign national knowing that they're unauthorized to work. The criminal penalties are saved to really the most egregious of circumstances. The civil penalties are escalating based on the severity of the violation and the number of violation. Repeat violators are, of course, penalized more harshly than those who are having it for the first time. And that makes sense because once someone, was reprimanded or had a certain violation, it's incumbent on them to be very strict about doing things right the next time around. Employment discrimination is another side of this legislation about employment authorization. Um, I I can assume that it comes in order to balance the fact that the employer really gain a lot of knowledge about the employee and has a lot of bargaining power in those initial phases, and the law want to prevent a situation when this relationship at this stage turn into something abusive. Um, it's of course, in our general legislation, discrimination based on immigration status is not allowed, other than against, of course, people who are not authorized to work under immigration law. That is allowed, and this is even required. The employer cannot hire someone who is not authorized to work. Discrimination against national origin also not allowed in this context, and it's not allowed in all circumstances. Immigration status discrimination is actually only prevented in situation where people are citizens or newly lawful permanent resident, meaning are not eligible to apply for naturalization yet. If a foreign national is a lawful permanent resident and they're already eligible to apply for naturalization but did not apply for their own reason, they don't get this protection. So if someone is a long-term LPR with 10 years of green card, and they come to work and the employer said, listen, I don't want to hire someone with a green card, just someone who's a citizen, that person might not have a recourse on that ground. National origin is always viable in that regard as a ground for discrimination and a claim against it. Document abuse is intended to prevent the employer from dictating to the employee what document to bring, because some people just don't have those documents, and they want to make sure that as long as they have documents that comply with the instruction on the I-9, the employer cannot say, no, I only want passport, I don't want social security card, or, I don't believe in driver's license from this or that state, so, I want you to bring something else. They cannot do it, and that's a ground for discrimination. And of course, like in many other pieces of legislation, retaliation against employees that complain is, of course, not allowed. And that should be fairly clear to understand why. E-Verify, we mentioned this is an electronic system that is, at the end of the day, will probably replace the I-9 as a mandatory system once USCIS reach a conclusion that everybody have computers already. And at that point, it's probably going to be mandatory. There's also a lot of pressure to make it mandatory in political debates and so on, because there's a belief that it provides better control and enforcement. We don't know if that's necessarily the case. The system is connected to certain databases of Department of Homeland Security and Social Security Administration, and database sometimes have mistake and sometimes are not fully updated and so on. So there can be false positive from the system or false negative, and then the employer has to go and find it. Um, the there are hundreds of thousands of users of E-Verify, and immigration, in order to promote the system, has been tying it to certain benefit, primarily as we saw the OPT extension for STEM graduate beyond 1 year and up to 3 years requires an employer that has E-Verify, and government contractors, especially for Department of Defense, must be using E-Verify in order to be eligible to get a contract. So the use of the system is growing. The accuracy of the system is obviously getting better over time. Um, but it's not a perfect system, and there are bugs and there are errors, but it seems that the way of the future is going towards this.